Okay.
She tested positive on 3/4 on March 4th for cocaine, Judge.
Can you bring her up, please?
And Judge, this is her first bond violation. If you'd be willing to
I
give
ordered you not to use. You're now testing positive for cocaine. That's unacceptable. No, I'm not going to let you go.
Welcome to breaking news from the US courtroom. A tense moment recently occurred when a defendant violated his drug ban again. Despite prior warnings, the test result came back positive for cocaine, leading to a resolute response from the judge. We will follow the details and legal consequences below.
Marijuana, alcohol. No, you're testing positive cocaine. Unacceptable. I order you not to use. Now I have to take further action to ensure that you're not using. First, I'm going to revoke your bond. You go into custody.
Judge, would you allow her to do a walkthrough bond?
No. I need you to realize that we mean business, that when we tell you not to use, especially cocaine, you're not to use. I'm sorry.
Would you set on that, Judge?
$5,001.
5,001. And Judge, I have two more. I have Enrique Flores. He missed a recalibration appointment. He was working in San Antonio. He does construction work. He didn't know he had that recalibration appointment. He's no longer in lockout. And so I think it was just an issue. He did not know he had that recalibration appointment, Judge.
This is not a burst bond violation with him missing.
I think it might be the second, Judge.
Judge, yes, this is the second. The first one was for the same thing.
Hello, viewers. Today's court session heated up with a repeat DWI case. Not only did the defendant miss his tracking device calibration appointment, but he also has a history of similar violations. The judge gave a stern warning about the serious consequences if he continues to disregard the law. What lessons will be learned from these warnings? Let's follow the next developments with us.
Take your time. No rush. Deputy, it's you going. I need your help. No? Did we let him go the first time?
Yes, Judge.
We didn't take him into custody the first time?
No, Judge.
Unacceptable. He now goes with you. No?
What would you set his bond at, Judge? 5,000?
What's the last name again?
Flores, Judge?
Thank you. I really don't know what it's going to take to get your attention that we're not going to stand for anyone endangering our public. Really. I mean, you've had in the last 3 years, 3 very serious cases, and now you're picking up a DWI. All of them are dangerous cases. What's it going to take? A 25-year sentence? Is that what it's going to take to get you to realize? All the stuff here is things that if you just think, they don't have to happen. All the time, all the money, all the just that you spend coming here can all be avoided by not using. You know what I mean? That's all it takes. From now on, what we're doing today, you're now facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? There are more proverbial slaps on the wrist. What you're pleading to now is a DWI. This DWI will go on your record. It will be there for the rest of your life. You can never take it off. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty to this case, like I said, it'll go on your record. You can never take it off. Do you understand?
Yes, Your Honor.
The other thing is this, is that your lawyer is asking to waive all the fines and fees. If you ever pick up another DWI, it is a $6,000 surcharge that you will be required to pay. And if you don't pay it, you sit 1 day for every $100 you owe. If you want to get lit, 52 beers, 32 shots of tequila, take a freaking Uber. $40 wherever you want to go in this damn city. Don't kill anyone. How do you plead to the DWI? Guilty or not guilty?
Yeah.
I'm gonna find you guilty and I'm gonna sentence you to 6 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 180 days. Don't get into a car. Driving on a suspended license case is just like a DWI. You pick one up, you're going to be right back in here, and it's just not going to go well for you.
Yes, Your Honor.
You understand?
Yes.
All right, good luck.
Thank you, Judge.
You were on bond for an assault case that have taken off on us at least 3 different times, and now you've picked up a new case. You were charged with failure to identify oneself while being a fugitive from justice. On that case, you're now facing a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir.
Today's court session witnessed a tense cat and mouse scene. The defendant, who was out on bail for an assault case, now faces a new charge, failing to identify himself when discovered as a wanted individual. The judge issued strong warnings, along with strict monitoring measures, including GPS tracking and random drug testing. Could this be the secret weapon to deter further disregard for the law? Stay with us as we break down the details.
On March 7, 2025, at approximately 4:44 p.m., an officer observed a vehicle with expired registration as of December 2024. A traffic stop was initiated. The officer made contact with the defendant. The driver advised he did not have any form of ID on his person and provided his name as Daniel Escamilla, date of birth April 24th, 1998. The officer did a search and saw the defendant did not resemble the Texas driver's license that came up for Daniel Escamilla. The officer got a hit for David Escamilla, the defendant's real name, and saw there was an outstanding warrant. The Texas driver's license photo for David Escamilla resembled the defendant. The officer utilized mobile APIS and confirmed that the defendant was David Escamilla. The defendant admitted to providing the officer with his twin brother's information instead of his own due to the open warrant.
Do you see if he has a license? Can you check, please?
Yeah, it's ineligible, Judge.
Okay. Mr. Escamilla, I'm going to have you sign an affidavit with me today. I don't give a rat's behind what is going on in your life. If you don't have a Texas driver license and liability insurance, you are not to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you get into a car. Do you understand?
Yes, Your Honor.
You have a lawyer, Mr. Escamilla.
No, sir.
I'm going to appoint you a lawyer today. Your case, your assault case is 1,000 days old. We are going to figure out what happens with this case today. Can you appoint him a lawyer, please? If this case gets reset today, you will get an ankle monitor, and I'm going to send you for a drug test right now. I want to ensure that you're not using anything as well. You know what? Let's just do that now. Police, if you can send him, please. If you fail to take the test, if you fail to come back, I'm going to make your bond so high you'll have hair falling out. Do you understand?
Yes, Your
The
Honor.
next time you take off on me and fail to come to court, so help me on those bonds. Do you understand?
Yes.
Take a seat for me. No more.
Yes,
You
Your
are
Honor.
not allowed to use. It is a condition of your bond. I will give you up to 50 days, and I'm going to test you again. If I find that you continue to use, I will put you in jail.
Yes, sir.
No more PR bonds for you.
Yes, sir.
You take off on me again, it's really not going to go well for you. Do you understand?
Yes, sir.
Okay, I put a GPS monitor on him and I've given him a curfew because he's taken off on us many, many times. His case is 1,000 days old. So I'll give you a reset, but I think that we were waiting on, is discovery complete on the assault case?
It says the only outstanding thing is a photo from the complainant.
Okay, if you can please
Yes.
get that.
Judge, just for the record, I was just appointed today. Okay,
No, I'll give you time.
thank you.
Sure. But I'm gonna test you like crazy.
Yes,
Just
sir.
get ready.
I'm working. Yes.
It's on your bond.
Yes, sir. Understand.
It's your responsibility to stay in touch with her too. If she tells me she can't get a hold of you because you're ducking and dodging, likewise.
Yes, sir.
Jail you will go.
Understand.
All right?
And
Okay, Ms. Tichy.
Yes, Judge, and we've had a long talk this morning,
Good.
and he was really good about communicating earlier.
and
Okay.
for my
Yes.
curfew, I work a night shift. I work 5 p.m. to 5 a.m. So
Judge, can it change to allow him to work?
I want proof. show me proof. I'm not gonna take your word
All
for it.
right, but she'll send it to me and by Monday I'll bring it in and we'll adjust. Does he need to be here if you're gonna adjust the curfew or can I just come show you?
Bring me legitimate proof and we can
And then we'll
talk.
talk.
And then, but remember, the GPS monitor tells me exactly where you go
Yes, sir.
at all times. So if you deviate,
Just worry back, yes, sir.
all right, okay,
I'll get the proof, Judge. Thank you so much.
yes, ma'am.
All right, go have a seat real quick.
I was appointed to Mr. Mendoza on your in-custody docket. He has 2 cases of assault family violence that was a prior bond forfeiture, and a failure to ID. I was appointed this morning on those cases and we have filed bail orders.
Okay,
On the older, we're requesting PR bonds, sir. On the old assault family violence, he did let me know, he was in communication with his attorney and the his appearances were being waived over in ERD court. I do show a reset from July 1st saying he doesn't need to appear and setting it for July 3rd where he does need to appear and his signatures are not on it. And he said he did not know. But
he picked up a felony violation upon condition.
that's correct, Your Honor. That was filed as a to-be warrant.
I don't know anything about the cases and I haven't spoken to him in a very long time. Does he speak English?
He does, yes, sir.
Great, I'm gonna have them, they're bringing him up?
Dear viewers, today's trial is heating up with a case involving repeat domestic violence and a year-long evasion of the law. The defendant not only has a prior history of assault, but also deliberately misled law enforcement by lying about his identity. The judge didn't hide his disappointment in the defendant's blatant contempt for the law, issuing stern warnings and threatening to revoke any chance of bail. Could this mark the end of the defendant's criminal streak? Stay with us as we follow the next developments.
He has not made bond on the felony case, so.
That's correct.
Good morning, Mr. Mendoza.
One second.
Sir, you're charged with 2 cases with us. You were charged with assault of a family member. You're now also charged with failure to identify oneself to a peace officer while being a fugitive from justice. That allegation kicks it up to a Class A, so you're also facing a year in jail and or a $4,000 fine. This case the assault is a year old. I have no idea what is going on with it, so I'm gonna have you refresh my memory real quick. What happened, please?
On the AFM?
Please. On all 3.
So on the AFM, which is the original charge, on April 6, 2024, officers spoke with a complainant witness who stated she was involved in a physical altercation with the defendant after the defendant became upset with her over food and struck her several times with a closed fist in the nose and mouth, causing her pain and visible injury. Officer observed the complainant witness to have a swollen bottom lip with a small laceration, and she was holding a bloody towel that she used for her nose. Defendant was identified by his Texas driver's license, and the defendant and the complainant witness have been in a dating relationship for 8 years. So that's the oldest AFM. Do you want me to do the felony?
Yeah.
Okay.
What?
So on the felony, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated the husband threw her on the wall after she called his mom to complain of his behavior. Complaining witness said she had a protective.
I didn't hear any of
Okay.
that.
Officer, on June 4th, 2024, officer responded to a disturbance call and spoke with the complaining witness. Complaining witness stated that her husband threw her against the wall after she called his mom to complain of his behavior. And then she stated that she had a protective order against the defendant. And then the failed to ID. On April 11th, 2025, officer dispatched to an unknown disturbance call for service. Officers arrived on scene, knocked on the door. Officers observed a male come to the door, but quickly move out of the way, not wanting to answer the door. Officers observed the defendant walking out of the door, stating that he was only having a verbal argument with his wife.
So
Officers-
now a new fight and that's what brings the cops to the house?
I believe so. Officer spoke to the female on scene. Officer stated the female was not answering questions due to not wanting to get the defendant in trouble. Officer observed the name and date of birth the defendant provided to officers were not coming through a TCIC search. Officers advised the defendant that if he does not have proper name and date of birth, he'll be charged with failure to identify. The defendant then confessed and provided his real name and date of birth. The defendant stated he did not want to go to jail for a warrant that he had. And then the officer observed that he had a felony and a misdemeanor warrant.
The reason I'm trying to you speak English, right?
Yes, sir.
The reason I'm trying to figure what's going on is because she's asking me to give you a PR bond, but
Yeah.
we've given you bond after bond after bond. You've been in flight status for about nearly a year. And now when the cops come to try to talk to you, you try to evade again. You know what I mean? Are we just going to continue to give you chance after chance? You continue to you just don't give a shice about bond conditions, man. Really? I mean, I get it that he may have not signed it or whatnot, but you can't just be out of sight, out of mind for an entire year and expect good things to happen. So, I mean, really, we've given you PR bond after PR bond. It would just, at some point, I have to say when, so that we mean business. There's no more revolving doors, Really.
Your Honor, the original AFN, it looks like they did do a RIP call. The complainant advised that the reason that she had a bloody nose is because she does drugs and was doing cocaine. He did have the PR bond. The VPO was a 2D warrant, so he wasn't given bond and didn't come on that one.
Yeah, but he had warrants out for both. Apparently knew about them. So I'm
Well,
not.
it didn't say that he knew about the felony warrant,
Well, I don't know,
He had
but
a warrant out.
but you can't make believe that he knew.
I mean, I can, if you want a bond reduction, I'm willing to give you a bond reduction. I'm not going to give you another PR bond, dude. Really. No more PR bonds. And you've got these cases out. Just, you can't out of sight, out of mind. And the only reason you're here now is because you got into another damn argument. So, Mr. Mendoza, I am now issuing another protective order on this case. And I want you to understand that the Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold someone at zero bond. This is now one of those cases. If you continue to violate protective orders, we can have a hearing to hold you at no bond. Do you understand? I don't want you to have contact with this person. No means no. Doesn't mean, please, baby, get me out of jail. Every phone call is recorded. Take note when you're making phone calls. Every phone call is recorded. Do you understand?
Yes, sir.
I'm not asking for much. All I want are my streets to be safe. And if you can,
Yes, sir.
just don't have any contact, don't have any weapons, and that's it.
Sir.
If you want a bond reduction, I'm happy to give it to you, but I'm not going to just continue to give homeboy PR bond after PR bond after PR bond. Just not,
Would the court be willing to reduce the bonds for $1,000?
I'll cut it in half. So on the assault, 2,500. I'm going to leave the failure to ID as is. But I'm telling you now, I don't know if you're going to get out, but if you do, there is a residential restriction. You cannot go within 200 feet of where she lives or where she works. Do you understand?
Yes, sir.
No alcohol, no illegal drugs. You will be randomly tested. No contact and no weapons. Do you mind? All I need you to do is file the MOA because we'll have him, pre-trial is going to, make sure that you're in compliance. All right, Mr. Mendoza. So what we'll do is the felony case is set for June. So what we'll do is, I don't like to set the people for more than 30 days, so you just don't get forgotten about. We can set you for 30 days, come back, and then, go from there. Okay? All right. Yes, ma'am. Thanks. Vic, what's the last name on the gentleman?
Wilkins, age 21.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Welcome to the latest legal news. Today, we are following a surprising trial and a moment of profound advice from the bench. A 21-year-old man stood accused of stealing his stepfather's guitar. But the courtroom took an unexpected turn as the judge challenged the evidence with sharp questions and offered heartfelt guidance about life, responsibility, and the future. How will justice unfold in this case? Stay with us to find out.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
No, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't
Fuck.
say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with the complainant.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, just based on the events, the defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the? I have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please.